The House will come to order. I am pleased to welcome you all to our last debate for this year. Context of the motions. A crippled man received a phone call from his wife, uttering just one name, the name of their neighbor. He immediately went home and saw his wife and son brutally murdered. He reported the matter to the police, but told him that it will be still investigated. Thinking that justice would not be served at all, the man took vengeance on his own hands. Knowing that he is physically not capable, he decided to burn the house of the suspect, which killed not only the latter, but also the wife and the son. The motion under debate today is, this House believes that the crippled man should be sanctioned with capital punishment for multiple counts of murder.
Representing the government are the Prime Minister, Shine, the Deputy Prime Minister, Sigla, the Government Whip, William, and the Government Reply, Moses. Speaking for the opposition will be the Leader of the Opposition, Deborah, the Deputy Leader of the Opposition, Joanna, the Opposition Whip, Mark, and the Opposition Reply, Bert.
On the behalf of the House, I extended a special welcome to everyone present. As your House clerks for today, we, Clara and Davidia, are reminding you on the rules of the debate. After 1 minute of delivering the speech, I will clap once to indicate the POI is already open. After the 6th minute, I will clap again to indicate that POI is no longer allowed. 10 seconds before the 7th minute, I will clap multiple times to remind the speaker that his or her time is up. I now call upon the Prime Minister to introduce the motion, define the terms, and outline the government case.
Good morning, honored adjudicators, fellow debaters, ladies and gentlemen. Welcome to today's debates, and we are from the government side. And I, Shine, stay as a Prime Minister. The motion for today is, this House believes that the crippled man should be sanctioned with capital punishment for multiple counts of murder. As the proposition, we strongly believe that the crippled man should receive capital punishment for multiple murders. To understand why, let me first remind the House of a tragic but undeniable fact of this case. A crippled man received a phone call from his wife, who managed to artfully name their neighbors before the phone call cuts. When he arrives home, he found his wife and son murdered. He then did what any citizen should do. He reported the matter to the police. The police told him that the case will be investigated, but instead of waiting for the due process, instead of trusting the law, he made a deliberate, calculated decision. Knowing he could not physically confront the suspect, he planned and executed an ordered attack on the neighbor's house. That fire killed not only the suspect, but also the suspect's completely innocent wife and son. People who have never been charged, let alone convicted of any case. But before we begin our actual argumentation, let me first define the key term in the motion: sanction and capital punishment. This key definition is from Corn Law School. First, sanction refers to a punishment imposed on party who disobey laws or court's orders. Second, capital punishment, also known as a death penalty. It is the execution of individual by the state after that person have been executed of a very serious crime. As a first speaker, I will present three main arguments. My first point is that this motion is about premeditated murder. Article 340 of Indonesian law states, any person who with deliberate intent and with premeditates the life of another person shall, being guilty of murder, be punished by capital punishment, life imprisonment, or a maximum imprisonment of 20 years. This applies directly to our case because the crypto man knew, or more likely have every reason to know, that an innocent family was inside the house, and yet he chose to proceed with this planned murder and deliberately cause their death. Under Indonesian law, that is premeditated murder, and this demands a full weight of justice. My second point is that it also concerns the presumption of innocence, but not for the crypto man, for the neighbor. In this case, we are not sure that the neighbor of the crypto man was the one who murdered his family. In this Article 8, Paragraph 1 of Indonesian law states, every person who is suspect, arrested, detained, persecuted, or brought before the court shall be presumed innocent until a final court decision proves guilty. This means the neighbor is legally innocent. There is no evidence proving that the neighbor committed that crime. Therefore, the crypto man had no right to take the law into his hand. My third and last point is that this motion rejects ventilated justice. A research from Universitas Gajah Mada shows 80% of crime targeting marked violence in Indonesia could have been resolved through a legal system. The crypto man shows anger over reason without investigation, evidence, or court procedure. Anyone can be a target. A jealous neighbor, or a false accusation, or a misunderstanding. As Professor Paul had warned, when people stop trusting the law, violence becomes normal and peace disappears. True justice is not anger. True justice is control, proven and lawful. So we believe that the crypto man should receive sanction with capital punishment for multiple counts of murder. Why? Because he did not put his trust in the police while we are still investigating the murder of his own family. Instead, he took revenge. He murdered an innocent family, not just one person, but 3 people. Under Indonesian law, that is premeditated murder. And for premeditated murder, that the punishment shall be capital punishment. For this reason, we urge you to affirm the motion. Thank you.
Thank you, Prime Minister. The Prime Minister spoke for 5 minutes and 29 seconds.
I now call upon the Leader of the Opposition to do her speech for 7 minutes.
Good morning, respected adjudicator, honorable opponents, and fellow classmates. The government said the offender should be determined by the death penalty because there are multiple people died, and our side of opposition side reject that argument. Of course, this case involves a tragic loss of innocent lives. Our side fully acknowledges the seriousness of the crime and the harm suffered by the victims. However, the issue before us is not whether the crime was serious. The crime was undoubtedly serious. The real question is whether the death penalty is the most proportionate punishment when significant mitigating circumstances exist, which is reduce the blame or punishment for an offense. Our side believes that justice must remain fair, rational, and proportionate. Punishment should reflect not only the outcome of a crime, but also the circumstances in which it was committed and the offender's level of culpability. Today, our side will demonstrate that major mitigating circumstances
significantly reduce the offender's culpability. That the death penalty is not the most proportionate punishment in this case, and that life imprisonment already provides a serious and effective alternative. If punishment is determined solely by the tragic outcomes of a crime, then the justice system stops evaluating the offenders as an individual. Instead, punishment becomes driven entirely by emotion, reaction, and public anger. That is not justice, no thanks. That is revenge. In criminal law, it is not important to consider not only what happened, but also why it happened and under what circumstances it happened. This is why mitigating circumstances are an important principle in criminal justice. Mitigating circumstances do not excuse the crime. They do not raise responsibility. However, they help to determine whether the most extreme punishment is truly appropriate. In this case, the defendant had just experienced several emotional trauma and personal loss. His wife and child had died, placing him in an extreme psychological and emotional condition. Under such circumstances, no thanks. Rational thinking, emotional control, and judgment can become seriously impaired. As human beings, we understand that people do not always think rationally when they are overwhelmed by grief and psychological distress. Criminal law recognizes this reality and therefore take mitigating circumstances into account when determining punishment. Yes, please.
You mentioned that the crippled man was led by emotional motivation, right?
Yeah.
But in the law, the motivation trauma the emotional trauma can't automatically remove his criminal responsibility. So how can you prove that the severity of his emotional trauma is suitable to the Article 44 of the Indonesian Criminal Code?
According to Article 84, the law just should considering the whole process, not only according the outcomes to give the death penalty to this person. And whether the neighbor was actually guilty is not the focus of our argument. What matters is that the defendant genuinely believes that this person was responsible for the death of his wife and child while experiencing extreme trauma. Our side is not excusing the crime. The defendant remains responsible for his action. However, criminal law recognizes that responsibility may be reduced when judgment is severely impaired. Criminal law distinguishes between a fully rational offender and an offender whose judgment has been substantially impaired by extreme circumstances. This distinction matters because justice requires us to evaluate the full context of a case, not simply the final outcome. No thanks. Therefore, although the defendant must be held accountable, the existence of significant mitigating circumstances means that the most extreme punishment is not automatically justified. The purpose of a law is not only to give the punish, but also to ensure justice. Furthermore, the death penalty is irreversible. Once carried out, there is no possibility for correction or reconsideration. This is why the justice system must exercise extreme caution before imposing the ultimate punishment. No thanks, especially in cases involving several emotional and psychological distress. In addition, life imprisonment already provides a serious and effective punishment. It permanently removes the offender from society, protects public safety, and ensures accountability without resorting to execution. Rejecting the death penalty does not mean allowing the offender to escape the responsibility. It means choosing a punishment that remains serious while still respecting the principle of proportionality. Our side is not asking to excuse the crime. We are asking the justice system to remain rational, cautious, and fair before taking irreversible action. Therefore, although the crime was serious, the existence of major mitigating circumstances means that the death penalty is not the most proportionate punishment in this case. Thank you.
Thank you, Leader of Opposition, for your remark. The Leader of the Opposition spoke for 6 minutes and 37 seconds.
Now I call upon the Deputy Prime Minister to give her rebuttal and additional arguments on the issue.
Well, ladies and gentlemen, the opposing group mentioned that they acknowledge the severity of the crippled man's crime, but they still deny the capital punishment. We know that capital punishment is the highest punishment in national law. So, and also we need to understand the essence of the crippled man's action, that is premeditated crime. So, if he killed someone deliberately, but he still cannot deserve the highest punishment, what kind of crime can deserve it? So, and also, the opposing group mentioned the emotional trauma, but according to the Article 44, only when the offender suffers from a legally recognized mental disorder or intellectual disability, so that the criminal liability can be removed. But I still want to ask, what is the evidence of his intellectual disability or mental disorder? And now I will continue my speech. So my first argument is based on the presumption of innocence and due process of law. Under law number 48 of 2009 on judicial power, Article 8, paragraph 1 states that every person who is suspected, arrested, or brought before the court shall be presumed innocent until a final court judgment proves guilt.
Yes.
You mentioned about the severity of the punishment and severity of the crime. If outcome alone determines punishment, can you explain why a drunk driver who kills 3 people should receive the same sentence as the hired assassin who kills 1?
You mean the crippled man didn't deserve the highest punishment?
Yeah.
Okay, I will respond later because I have 3 arguments to prove that. I have 3 arguments to prove that he deserves. And the neighbor in this case was only a suspect according to the presumption of innocence, right? There was no final court judgment, and the case was still under investigation. Yet the crippled man still chose to ignore the legal process and take justice into his own hands. Now I will reply Mark's question. If individuals can allow to decide who deserves punishment based on only suspicion, but so that then anyone could be a victim of personal revenge or emotional reactions. So, most importantly, we cannot ignore the consequence of his action. The fire killed not only the suspect, but also the suspect's wife and son, who are never proven guilty of any crime. Their deaths demonstrate why legal procedure exists, the protection innocent people from improper punishment. And my second argument is that this case cannot legally be justified as self-defense. Some people may attempt to emotionally frame the man as a desperate husband and father who still lives next to the danger. But why this was not an act of immediate protection? A useful comparison is the famous Indonesian Amak Sitan case. In that case, a man killed a robbery during an ongoing robbery. Killed an attacker during an ongoing robbery. And the act was recognized as self-defense. Why? Because the threat was immediate and unavoidable. So, let's move to the essence of this crippled man's action. He planned everything and So it proves that he has a clear mental order and logic. So it's a kind of deliberate murder.
POI.
No, thanks. However, this motion is different. The danger had already ended, and the wife and son already died.
POI.
But the crippled man later chose to burn down the house deliberately with preparation. That is the revenge, not self-defense. And self-defense is permitted
POI.
only when there is an immediate threat that leaves no reasonable alternative. Once the threat has
POI.
ended, law no longer allows a person to use violence.
If premeditated murder automatically justifies execution, why does Article 459 of the Indonesian Own Criminal Code provide 3 sentences options, not just one?
Well, it's not suitable to apply it in this case because you mean lifetime, choice of lifetime, right?
Yes.
But you know,
Because you mentioned premeditated murders equals to justification of death penalty.
there is multiple victims, and so it's really severe it's really severe in this case. And he killed not only the suspect but also suspect's wife and son. You know, although he know the wife and son may be died in this fire, he still do that. So we can define it as a premeditated murder. So it must deserve highest punishment.
Point.
No thanks. And my third argument is about the emotional pain and criminal liability, which can respond Deborah's speech. So the man experienced extreme emotional devastation, but the law doesn't say that the anger, trauma, or emotional suffering automatically justifies murder. In legal terms, it can explain the behavior, but explanation is not required. It is not equal with justification. So, finally, we must consider the severity of the crime itself. The house was burned deliberately and with preparation. The act results in innocent deaths. The man's behavior demonstrates extreme indifference for human life. For these reasons, the man should be fully responsible under the law, and he deserves capital punishment. That's all. Thank you.
Thank you, Deputy Prime Minister. The Deputy Prime Minister spoke for 6 minutes and 52 seconds.
I now call upon the Deputy Leader of the Opposition to do her speech for 7 minutes.
Good morning, everyone. Before I begin my main argument, I will briefly respond to what the government side just said. We agree that this was a serious crime. We agree that the innocent people died. We agree that the offender bears criminal responsibility for his action. But our argument does not depend on whether the neighbor was actually guilty. However, they equated the seriousness directed with a death punishment. Okay, so as our first speaker has already demonstrated that this case involves significant mitigating circumstances, now I will address a follow-up question. Once those circumstances have been taken into account, does Indonesian law require the court to impose the death penalty? Our answer is no. Even if we accept that it's a serious crime, it does not automatically follow that the death penalty is the most appropriate punishment. So the real question is that why must the court choose the death penalty is the most appropriate punishment? So the real question is that why must choose death rather than another severe punishment that is already available under the law? This leads to my first argument. Death punishment is not appropriate in this case. According to Article 459 of the new Indonesian Criminal Code, and any person who with prior planning tasks the life of another person with a capital punishment or life imprisonment or imprisonment for a maximum of 20 years. Article 459 provides 3 sentencing options.
PLI.
Okay.
The question is, we completely understand the tragic loss of the Crippled man's family, but you could please explain to the House how could the neighbor's completely innocent wife and son were responsibility for that grief. If your side reject capital punishment for a man who actively chose to burn an innocent mother and a child alive, where is your sense of justice for them, and where is your warmth of law for them? Thank you.
Okay. Now we cannot deny that we have to acknowledge that the citizen's death is unchangeable, and we agree that justice must down for the citizens, but justice not means that the others to die, and then we have to use rational law to give response. Okay, so.
POI.
Article 459 provides 3 sentencing options, which demonstrate that Indonesian law does not treat all cases of premeditated murder alike. If every offender automatically deserves execution, the other sentencing options will not exist. And
POI.
also, it leads to a more important question. If the law already allows life imprisonment, the government must explain why execution is necessary rather than another severe punishment.
POI.
Okay.
Yeah. So as you were saying that there are 3 different levels of punishment for the premeditated murders, right? We have, as we have explained multiple times, the reason behind that is the suspect, like the crippled man, holds 3 accounts of mass murder, and then you were saying something about the rational law. That's why we need to use rational laws for the crippled man's case. Then I would like to ask that. How do you define this rational law when a man holds 3 counts of premeditated mass murder should not be death penalty?
Okay, as our first speaker said, we also have to consider the whole process and the mitigating circumstances. This also, I will explain later. So the reason this burden exists is because the death penalty is the most severe punishment. According to the Article 98, declare the capital punishment is strengthened as an alternative as a last resort to prevent the commission of crimes and to protect the community. Last resort means it should be applied only when another punishment are insufficient. Therefore, we believe that life imprisonment may be substituted for death punishment in this case. This is also our second argument and as a resolution. Even if we accept that severe punishment is required, the government must explain why life imprisonment is insufficient. Under the new Indonesian criminal code, there is a clear humanization trend in sentencing philosophy. The law has shifted away from pure retribution toward greater emphasis on human rehabilitation and the principle of ultimate remedy. That punishment should be the last resort. This is reflected in Article 98. More importantly, the significant mitigating circumstances in this case, which have been mentioned in Article 53, paragraph B, requires court to consider the motive and purpose of committing the crime. His physical disability limited him. The profound grief and desperation caused by the brutal murder of his own wife and son, as well as the sense of helplessness arising from the feeling that the authority failed to deliver justice. Okay.
POI, okay. So actually, we're doing total. But first, you said something about we should focus on rehabilitation, not execution. Then how do you rehabilitate someone who believes that bypassing the courts and burning the innocent children alive is an acceptable way to solve this problem? And as well as you were arguing that this is some part of the police fault, are we seriously arguing that whenever the police are too slow or they were actually doing the investigation, the citizens have the right to become the judge, the jury, and the executioner? Thank you.
Okay. So,
Excuse me, I'm going to
So, according to men, driven by overwhelming personal tragedy and perceived systemic failure in fundamentally different from a cold-blooded murderer who kills for gain or pleasure. Therefore, in this case, life imprisonment not only protects society and holds justice, but also aligns with the rehabilitative spirit of the new law. Therefore, our position is clear: a serious crime may justify severe punishment, but it does not automatically justify execution. So I hope you guys can explain why death punishment is not necessary. For this reason, we oppose the motion. Thank you.
Thank you, Deputy Leader of the Opposition. The Deputy Leader of the Opposition spoke for 7 minutes, 27 seconds.
I now call upon the government whip to deliver his speech, rebuttals, and cash points analysis. Please be reminded that you are not allowed to provide new arguments. And please remember, POIs only 10 seconds, every 10 seconds, and you are only allowed to say your POIs within 15 seconds. Thank you.
Ladies and gentlemen, we have now arrived at an interesting moment in this debate. The opposition appears to have partially conceded the question of guilt. They are no longer arguing that the crippled man is innocent. They are arguing that the capital punishment goes too far. Thus, a lighter sentence is more appropriate. This is actually progress, but it does not win them the debate, because the motion before this House will not what is most lenient sentence possible. The motion is whether capital punishment is a lawful and appropriate sanction, and on that question, the government stands firmly in the affirmative. Let us return to the text of the law. Article 340 of the Indonesian Criminal Code provides 3 sentencing options for the premeditated murder: capital punishment, life in prison, or a maximum imprisonment for 20 years. This choice belongs to the court, not to the House, not to the opposition, and not to us. What we are affirming today is that capital punishment is one of those lawful options. We are not demanding the court ignore all mitigating factors. We are not saying disability and trauma are irrelevant to sentencing. We're saying that for a man who deliberately and premeditation caused 3 deaths, including 2 completely innocent lives, capital punishment, no thank you, is legally available and morally defensible. The opposition's argument against capital punishment is actually an argument about judicial justice. And judicial discretion already exists in Indonesian law. A court will weigh everything. That is exactly how the system is supposed to work. Go on.
Indonesia has barely executed anyone since 2016, nearly a decade, yet serious crimes continued. Where exactly is your empirical evidence that execution deters crime better than life imprisonment?
So, the Article 100 of the new Indonesian Criminal Code, W number 1 2023, which mandates 10 years probation period for death sentences oriented toward rehabilitation. If they use this argument, they are actually making our case for us. So, the Article 100 shows that Indonesian law has evolved. The death penalty in modern Indonesia is not an automatic but immediate execution. It is a sentence that includes a formal period of assessment, rehabilitation, and review before any execution is carried out. The crippled man would have full legal recourse, full time for review, and full opportunity to present mitigating circumstance during that period. The opposition cannot simultaneously argue that capital punishment is cruel and then cite a law that explicitly humanizes the process. The existence for Article 100 proof that capital punishment in Indonesia is implemented truthfully, and it is still appropriate session for multiple course of premeditated murder. So, the opposition framed this as a punishment of one man for one act of desperation. Let us correct that framing with the facts. So, 3 people died. One was suspect, a man who, I remind this House, has not been convicted of anything. 2 were completely innocent, a wife and child who had no involvement in any crime, who were not executed for anything, and who died because of a decision one man made in the middle of the night. So when we talk about proportionally, we must talk about the full weight of what was done. 3 deaths, 2 of them entirely innocent, carried out through the method which is arson. Thus the perpetrator chose specially because it would guarantee their deaths. The opposition wants to give this a lighter sentence, but proportionality cuts both ways. If more lives taken, the more serious the legal response must be. So beyond this individual case, the sentence sends a message to a society. If Indonesian courts respond to multiple premeditated murders with the most lenient available sentence, no thank you, what message does that send to every citizen who feel wronged by the system? It tells them if you kill enough people, then you have a compelling personal story. The law will go easy on you. No, that is a message that endangers every innocent person in this country. So go on.
If mitigating circumstances do not affect sentencing in a capital case, what is the purpose of recognizing mitigating circumstances at all? Thank you.
So there are other houses arguing that the crippled men also deserve justice, which is really irony. Well, justice is meant for the people who live under the law. If you can't follow the law, the justice will not cover you. Because those people who follow the law will get covered by the justice. That's how law is supposed to work. So, ladies and gentlemen, proportionality in law means matching that severity of the punishment to the severity of the crime. 3 premeditated deaths, including a woman and a child, represented the most severe category of crime in the Indonesian legal system. Capital punishment is not disproportionate. It is the law doing exactly what it's designed to do. The government stand firm. Thank you.
Thank you, Government Whip. The Government Whip spoke for 5 minutes, 24 seconds.
I now call upon the whip of the opposition to do his speech for 7
Good morning, respected adjudicators and honorable opponents. At this point in the debate, both sides have laid their cases before you. You have heard from our leader of opposition, who established that significant mitigating circumstance fundamentally reduces culpability, making the death penalty a disproportionate response. Also, you also have heard from our deputy leader, who demonstrated that under Indonesian law itself, specifically Article 459 and Article 98 of the 2023 Criminal Code, that death penalty is not required, not mandatory, and must only be used as a last resort when no other punishment can adequately protect society. Today, the government case collapses on a single fundamental flaw. They confuse emotional vengeance with a civilized legal system. They argue that because a horrific crime occurred, the death penalty is the automatic answer to rebut the government with. The government argued he used a weapon of mass destruction and accepted the uncertainty that everyone inside the house would die. The opposition, the counter for this is that the government is assuming that the man had a normal functioning mind capable of predicting the future, and at the exact moment he did not. When the government talks about dolus eventualis, conditional intent, the law assumes a regular person sitting down and waiting consequences. But this man's brain was entirely hyper-focused on a single moment, a single object, the killer of his family. In psychology, severe trauma causes tunnel vision. In his mind, physically, no thank you, could not process to existence of the neighborhood, a structure, or other family members. To him, the house was the suspect. He did not trade the lives of an innocent mother and child. He literally did not register their presence because his mind was entirely consumed by the image of his own slaughtered child. You cannot have intent, even conditional intent, for the things your brains, your shattered brain cannot even process. No, thank you. So, as the government prime minister argued earlier that the severity of the outcomes justifies the severity of the punishment, but if the outcome alone determines punishment, then we no longer need court, we no longer need judges, we no longer need the law. No, thank you. Think of this way. If the only thing that matters is how many people died, then justice becomes just a simple math. 3 people died, execute. No, 2 people died, life sentence. 1 died, 20 years. That is what the Prime Minister was proposing in this argument. Hence, that is not. No, thank you. That is not how any functional legal system works, and it is certainly not how Indonesian law works. Moreover, the government deputy prime minister argues that premeditated planning was present. Therefore, that penalty is justified. We, the opposition, acknowledge planning occurred, but take notice the government failed to dispute with us the Article 459 of Indonesia. No, thank you. Criminal Code. The court gives 3 sentencing option of premeditated murder as capital punishment, life imprisonment up to 20 years, or up to 20 years imprisonment. Note that if the law automatically... No, thank you. Note that if the law automatically required execution for every premeditated murder, why then those alternatives exist? I'll tell you why. Because the law itself recognizes that not all cases are equal. Neither are the offenders and neither are the circumstances surrounding the crime. This is a major flaw which the government has failed to address. So in our defense, on the mitigating circumstances... No, thank you. But they argue... On the mitigating circumstances, they argue that trauma does not excuse the crime. We, the opposition, have already agreed and never said otherwise. This is because there is fundamental distinction between the two, and which the government has deliberately blurred throughout the debate by avoiding the actual government. No, thank you. As stated in the Indonesia Criminal Code Article 54, where it requires court to reconsider the offender's motive, mental attitude, personal circumstance, and the circumstances surrounding the offense when determining the sentence. Furthermore, as the government ignores mitigating circumstances, they do not blindly neglect our argument, but they dismiss the law itself. Moreover, on the question of deterrence, the government implied that the harsher the punishment means stronger deterrence, the lesser the crimes. Highly unlikely. The ICJR documents that Indonesia has barely executed anyone since 2016. That is almost a decade of very few executions. If harsh punishments truly deterred crimes, serious crimes should have increased dramatically during the period of time because people had new execution was unlikely. Their claim is deterrence does not hold. There is no empirical evidence presented, and assumptions and statements without evidences are just mere opinions. Therefore, the government has yet failed again to dispute this case. So, members of this House, let us now go deeper as the debate was never about the crime occurred, but whether that is necessary and proportionate and just to the response of the specific crime committed, specific person, and under this circumstance. So, and on the question, the government has constantly failed, and here's why. First, once carried out, that penalty cannot be undone. No new evidence, no appeal, no correction. The article 1998 of the 2023 THBT designates the death penalty as a last resort, reserved only cases where no lesser punishment can adequately protect society. So ask yourself, does life imprisonment protect society? Yes. No, thank you. Does it punish the offender? Does it ensure full accountability? If the answer is yes, for what and why exactly does execution provide that life imprisonment cannot? So the government has no answer to that question. Their silence speaks louder than anything that they have said today. So, and the second point is that our opposition leader, established that this man returned home to find his wife and child brutally murdered. He reported it to the authorities, yet they implied inaction. He was not a criminal. He was not a predator. He was a physically disabled, grieving father, abandoned by the very system now that seeks to execute him. Now, members of this House, we never asked you to free this man, to forget the victims, or even ask you to treat this crime as anything less as what it is. What we ask you is that as far simpler than that. We ask you to look at this man fully, not just what he did, but who he is and what he went through, and what the law actually requires before taking his life. We ask you to hold the justice system to its own standard. Because system that only sees the worst moment of a person's life and nothing else is not a justice system. It is a revenge system. And this House deserves better than that. For those reasons, standing firmly on the case built by our opposition team, we are proud and loud to oppose. Thank you.
Thank you, Opposition Whip. The Opposition Whip spoke for 7 minutes and 17 seconds. I now call upon the reply of the opposition to do his speech for 4 minutes. Remember that you are not allowed to give another argument.
The government is actively trying to blind and limit us. Position yourself in this scenario. You stand for a man who committed a crime. 5 people died. Officials stating that they will investigate. Evidence all points towards this man, and justice requires this man to die. My respected audience, from the very beginning, the government delivered several points. Our focus today is pointed towards a single question. Throughout this debate, did the government actually prove that death is really necessary instead of merely being available? To us, the government failed to do so. First of all, they mentioned about premeditated murder and could have been solved and immediately giving their answers of capital punishment. Question, had they answered that circumstances matter? Surely, they mentioned about the KUHP law. However, they need to understand and observe it word for word, because it is clearly stated in the KUHP law itself, on 459, it says about you need to focus on the severity of the case as well. Premeditation tells us that he thought before acting. However, it does not tells us that he acted with the same moral depravity as the contract killers, terrorists, and other serial murderers. Planning alone cannot justify the ultimate punishment. Another thing is actively ignoring the mitigating circumstances itself. Murder cannot be judged in isolation from its cause. Government wants you to see the final act and ignore everything that has been built up to it. Every legal justice system distinguishes a person who kills for profit, which is fame, money, and other personal gains, and a person who kills under extreme emotional, psychological, and physical distress. These also affect the blameworthiness of the person. Government wants to punish him as if he began the story as a killer. However, spoiler alert, he doesn't. He began the story as a victim. Justice must recognize what was done to this man and not place him among the other offenders whom death is justified. And I want to quote also the statement from the government where they said that where is our sense of justice? Where our sense of justice stands stands in front of stands in front one who acknowledges the law and acknowledges the person. Unlike the government who only acknowledges the law, we also acknowledge the person. We're not trying to erase the guilt from this person. We're trying to open your eyes and see the reality of this man, to put you in his shoes and to experience what he experienced as well. Remember that he's a crippled man, he loves his family, and them being gone means that they will go through unimaginable amount of physical, emotional, and psychological distress. The action was a consequence of extreme trauma and emotional devastation, not cold-blooded murder or malice. The question now is, does this man truly belong in the same moral category of the others? Finally, the government should see that the death sentence is the final sanction. It exists to guide the community and being an alternative punishment. Again, this is also stated in the KHP mentioned by my deputy leader and leader as well. Remember that capital punishment does not flow into the system that easily. It is the final conduct. The easiest thing to do in this world is to see the condition, the crime, the person, and give the heaviest, most harsh punishment possible without considering the circumstances and taking things into account. When we take a step back and see the government's details and their entire speech, they undoubtedly say that they also support the law and but not support the person as well. And so, justice is not about giving the harshest punishment possible, but it is about giving the right one for this man as well. Thank you.
Thank you. Opposition reply. The opposition reply spoke for 4 minutes and 3 seconds.
I now call upon the last speaker, reply of the government, to do his speech for 4 minutes. Remember that you are not allowed to give another argument.
Mr. Oh yeah, actually, but Oh, okay. If I have it, it's better, right? Okay, Mr. Random Speaker, ladies and gentlemen, as our final speaker for the government, this is my duty to bring this debate to a logical conclusion by filtering out all the emotional noise and evaluating the core clashes of this round. But throughout this debate, the opposition side has tried multiple times to build their case on a classical appeal to emotion. They have painted a vivid picture of a grieving, paralyzed father, extremely traumatized, and then arguing that he's suffering demands mercy. However, if the opposition chooses to rely on this narrative, they actually fail to understand the differences between explanation and justification. In a court of law, emotional trauma can explain a person's motives, but it can never legally justify mass murder. And killing 3 innocent lives is mass murder, right? And then it actually brings us to this question that being a victim of a crime is absolutely a tragedy, but since when does being a victim give you the legal right to turn around and murder 3 other people? Right? As Shine and Sidra have previously established, under Article 340 of the Indonesian Criminal Code, premeditation does not require a cold, unfeeling criminal mastermind like a high-intelligence psychopath. It simply requires a distinct period where an individual has the capacity to think, adapt, and plan. Well, the moment this man sat down, cautiously evaluating his physical limitation, right? He's crippled, and then strategically chose arson as his weapon. He set on fire. And then this action crossed the line into the cold calculation of mass murder. The law must rule by objective evidence, not by tears. And also, let me just put everything into plain words. All right? The opposition preaches that the law needs to be warm and compassionate, right? Basically saying that we need to give mercy to this crippled man. But but please tell me, right? Where is this warmth and mercy when the defendant sets on fire and burned an innocent woman and her child alive? Where, if the warmth of the law means granting infinite mercy to mass murder while turning around a blind eye to the innocent victims who died in agony, isn't this the most hypocritical and cruel from the warmth word, right? So actually, if you think about it, our government side, we are standing in a way different perspective. The opposition, they stand behind the crippled man who deliberately killed 3 innocent alive, illegally speaking, and us, the government side, stand with the innocent, dead wife and son. Well, as a capital punishment in such extreme case is not vengeance, like what the crippled man did. It is an affirmation of human values, which is the affirmation of the values of the wife and child. Ultimately, Madam Speaker, ladies and gentlemen, if we accept the opposition's logic that the citizens can bypass the courts and play judge, jury, and the executioner whenever they feel that an investigation is taking too long, then we are voting for the total collapse of the legal systems. And at the moment that we excuse vigilante justice, we replace constitutional order with chaos. The rule of law exists preciously to protect the innocent. The very innocent this man chose to burn alive. And for a safer, more stable, and just society, the government firmly wins this debate. Thank you.
Thank you, government reply. The government reply spoke for 3 minutes and 51 seconds.
On behalf of the House, I thank everyone for the cooperation. I congratulate all the debaters on their performances. This debate is now concluded. The House stands adjourned. Thank you.